A termination notice is a critical component in the eviction process in California because it serves as the formal legal notification to the tenant that the landlord intends to end the tenancy. Without a valid termination notice, the entire eviction process may be invalidated, as it is the foundation upon which an eviction case, or unlawful detainer action, is built. Importance of the termination notice in eviction proceedings. California law requires that landlords provide tenants with a proper termination notice before filing an unlawful detainer lawsuit. This ensures that tenants are given adequate warning and an opportunity to comply, vacate, or dispute the claim. If the landlord skips this step or serves an improper notice, the court may dismiss the eviction case. Sets the basis for the eviction. The termination notice clearly states the reason for the eviction: non-payment of rent. A 3-day notice to pay rent or quit informs the tenant of overdue rent and gives them a chance to pay or move out. Violation of lease terms. A 3-day notice to perform covenant or quit gives the tenant the opportunity to correct the violation. No-fault evictions. A 30 or 60-day notice to terminate tenancy applies to cases like owner move-ins or substantial renovations under certain conditions. This written reason becomes the legal argument in court if the tenant challenges the eviction. 1. Compliance with tenant protection laws. Under California Tenant Protection Act, AB 1482, and local ordinances, specific rules govern what type of notice must be provided. Just cause is required for eviction in many cases. Notices must comply with local rent control or tenant protection laws, for example, Los Angeles Rent Stabilization Ordinance. The termination notice protects tenants from retaliatory or arbitrary eviction by requiring the landlord to document a valid legal reason for ending the tenancy. Establishes the timeline. The termination notice sets the timeline for compliance, which is important for ensuring that the eviction progresses smoothly. For example, a 3-day notice to pay rent or quit gives the tenant 3 business days to pay rent or vacate before the landlord can file a lawsuit. A 30 or 60-day notice to terminate tenancy gives tenants time to relocate in no-fault evictions. Evidence in court. In an eviction trial, the landlord must present the termination notice as evidence to prove the tenant was properly informed of the landlord's intent to terminate the tenancy. The landlord followed the legal procedure and allowed the tenant a chance to cure the issue, if applicable. An improper notice, for example, incorrect dates, missing key details, or inadequate service, can result in the case being dismissed. Termination notices protect both sides. They give landlords a clear way to remove tenants. This is important if a tenant doesn't pay rent or damages the property. For tenants, the notice provides a warning. They have a chance to fix the problem. This helps them avoid court and keep their housing. The notice also gives tenants time to find a new place to live. It makes the eviction process less disruptive. This includes the tenant's name, the address, and the reason for termination. The notice also needs the correct deadline. This varies by state and reason for eviction. Not following the rules can be costly. A judge can dismiss an eviction case. This is if the landlord didn't give a proper notice. The landlord may have to start the process over. This can be expensive and time-consuming for landlords. For tenants, it can cause unnecessary stress and uncertainty. Type of notice. Must match the reason for the eviction. For example, 3-day notice for non-payment, 30-day notice for no fault. Specific details. For rent-related notices. Exact amount owed, how and where to pay. Proper service. Must be delivered in person, substituted with a co-occupant over 18 and mailed or posted and mailed. Thanks for watching. If you found this helpful, don't forget to like, share, and subscribe for more insights. See you in the next one.